we have the petitioner team number, please?
18.
And the first speaker's name?
Andrew Ferguson.
Second speaker's name?
Shannon Healy. Healy, Healy.
Respondent team number?
17.
First speaker's name?
Alan Carrillo, Carrillo. LLO. Yes.
Second speaker's name?
Aaron, Aaron. Kamako Vivo Ole. My friends at the bar refer to me as Mr. Ken.
How would you like to spell your times?
I'll be speaking for 9 minutes, my co-counsel 8 minutes, and a 3-minute rebuttal.
Petitioner ready to proceed?
Mr. Chief Justice, and may it please the court, my name is Andrew Ferguson, and my co-counsel Shannon Healy and I represent the petitioners, Bobby Bronner and Chester Comerford, at the case at bar. At this time, I respectfully request 3 minutes for rebuttal.
So granted.
Thank you, Your Honor. I'll be addressing the issues surrounding the Commerce Clause, while my co-counsel will be addressing those pertaining to the 14th Amendment. Petitioner asks that this court rule that Congress, in enacting the Affordable Health Care Act, exceeded its constitutional authority under the Commerce Clause. To this end, I offer the following 2 reasons. First, that the Affordable Health Care Act exceeds the granted regulatory and protection authority of the Commerce Clause. And second, that the Affordable Health Care Act fails to meet the requirements of the Commerce Clause as established in Perez v. United States. The wording of the Commerce Clause itself gives Congress the right to regulate commerce among the several states. From this right to regulate, this court has inferred the right of protection. In Perez v. United States, and also supported in United States v. Lopez, United States v. Morrison, and Gonzalez v. Rake, this court established the 3 categories of Commerce Clause jurisdiction. First, the channels of interstate commerce. Second, the instrumentalities of interstate commerce. And third, those activities which exert a substantial effect on interstate commerce. In all 3 of these categories, this court granted Congress only the rights of regulation and protection. It was the regulation and protection of the channels of interstate commerce, the regulation and protection of the instrumentalities of interstate commerce, and lastly, the regulation of those activities that exert a substantial effect.
Counsel, how is protection relevant at all in this case at bar?
Your Honors, these are the only 2 rights given to Congress under the Commerce Clause. In the insurance mandate in the Affordable Health Care Act, Congress exceeds those 2 rights by mandating participation. Even in our this court's broadest rulings under the Commerce Clause, Congress has been limited to protection and regulation. In Wickard v. Filburn, Congress had the right to regulate the growth of wheat in order to protect the larger interstate wheat market. And in the case of Gonzalez v. Rake, the court was allowed to regulate the growth, transfer, and consumption of medicinal marijuana because of its larger impact on the interstate illegal marijuana market.
All right, so counsel, why couldn't respondents say this act is trying to protect their higher insurance rates by widening the pool of people who have insurance, you'll lower rates? Why is that not protecting the people who already have insurance?
Your Honor, because the means used do not simply just protect an industry, such as in the case of Gonzalez v. Rake, regulating the growth, transfer, and consumption of medicinal marijuana, or in the case of Wickard, regulating the growth of wheat. In this particular case, the Affordable Health Care Act mandates that individuals who are not presently participating in the health insurance industry to purchase insurance.
Well, counsel, they may not have insurance, but I don't know if the record is clear whether or not they've ever participated. I mean, one can participate by going to the emergency room, getting sick, or so on.
Yes, Your Honor. People may participate in the healthcare system, but that does not necessarily mean that they are part of the health insurance industry. According to the record on page 6, paragraph 2, there are approximately 40 million people who do not have health insurance. By mandating that these people purchase health insurance, Congress is exceeding its constitutional authority of regulation and protection. If this authority was applied to this court's jurisprudence under the Commerce Clause, the effects would be terrible. In the case of Wickard versus Filburn, Congress would not only have the right to regulate the growth of wheat, but it could actually mandate participation in the wheat market by either purchasing so much wheat or could actually require people to grow wheat on their property.
Counsel, returning to Chief Justice's argument a moment ago, I understand your point that this isn't the healthcare industry being regulated, and I think it's a valid point, but don't the 40 billion people that do not have health insurance have an impact on the interstate economy? I mean, we have 40 billion people here who, if they go to the emergency room and are unable to pay for the cost, and the burden falls on the building itself, the administration of that hospital, family and friends to pay for the cost, the doctors. Doesn't this place an undue burden on them?
Yes, Your Honor, there may be in fact being a burden, but as this court ruled in United States versus Lopez and also sustained in United States versus Morrison and Gonzalez versus Ray, in order for an activity to be considered under the substantial effects test, there must be economic activity present. The non-participants of the health insurance industry do not constitute economic activity.
But they still pay their health bills one way or another. So they are still participating economically in this industry.
Your Honor, they are participating economically in the healthcare industry, but not the health insurance industry. The sole justification provided for the insurance mandate in the Affordable Health Care Act is seen in Section 2I of Appendix 2 of the findings under the Affordable Health Care Act, and that is to lower health insurance premiums. The reasoning is...
Isn't health insurance part of the healthcare industry? How do you define healthcare, and how is it distinguishable from health insurance?
Healthcare would be providing for such injuries as injuries and sickness, while health insurance is merely a means for paying for that service. Health insurance, thus, is only a means of paying for that service, and it doesn't constitute the actual healthcare system.
So are you contending that health insurance is not part of the healthcare system? They don't relate or correlate at all?
Your Honor, in this society, health insurance is a common means of paying for health care, but at its core, healthcare and health insurance are very distinct. And as such, even though Congress may regulate healthcare or health insurance, they cannot justify the mandating of participation in the health insurance industry because people are part of the healthcare system.
Counsel, you make an effective argument about not forcing people to participate. Don't the facts indicate that Comerford had a health insurance policy already, and thus he had participated in the insurance economy?
Yes, Your Honor, he may have had a policy before, but according to the facts, he did not have a policy then. That's why they were seeking to find an insurance policy as a married couple.
Just so I understand, he didn't have a policy at the passage of the Health Care Act in Olympus.
Yes, Your Honor, and according to the facts, they were content with the insurance that they had under Denolf Industries. But once the Affordable Health Care Act was passed, then they sought to find insurance. It was only when the insurance mandate took place that he sought for more insurance. And this exceeds the congressional authority under the Commerce Clause. And since there is no commercial activity present because they are not purchasing health insurance, it cannot be regulated under the substantial effects test. And also the other two categories under the Perez test are first the channels and the instrumentalities. Under the channels, this court stated in Caminetti versus United States, cited in Perez versus United States, that the channels of interstate commerce include the roadways, highways, airways, waterways, etc., and that it would allow Congress the right to protect them from misuse and threats. The Affordable Health Care Act's insurance mandate clearly does not deal with the channels of interstate commerce or protecting them from misuse or threats.
Counsel, say you make a very persuasive argument, assuming this court finds there is no economic activity. But say we did find there was. Could petitioners still defeat the passage of the Health Care Act under a rational basis review?
Your Honor, in this particular case, there is in fact no economic activity present. It would be an entirely different matter if there was. But if we look to the qualification established in Lopez and Morrison, since there is no commercial activity present because people are not participating, Congress has no right to regulate those individuals.
Counsel, what I'm saying is, if we were to find the activity was the people who are uninsured going to the emergency room, getting sick, driving up the health care costs for everybody else, such that there was an economic activity, could petitioner refute the law under rational basis review?
Yes, Your Honor, even though Even though this Congress may justify themselves under the regulation of the health insurance industry, they could not justify the use of mandating participation in an industry. There is no example of this in this court's precedents under the Commerce Clause. And since this court has never recognized non-participation as an activity, and the Affordable Health Care Act's insurance mandate fails to meet the requirements of the Commerce Clause, and the force used by Congress exceeds it. Thank you, Your Honors.
Mr. Chief Justice, and may it please the court. My name is Shannon Healy, and I represent Mr. Bronner and Mr. Comerford on the issue of the 14th Amendment. Today, we ask the court to rule that a marriage license granted in one state must be recognized by all states. There are two possible grounds upon which the court could rule today. The first recognizes Mr. Bronner and Mr. Comerford's fundamental right to travel freely between the states. The second issue is that they have a fundamental right to marry. There's also a tertiary issue of the fact that Olympus has violated the full faith and credit clause. It's important to distinguish between the two main issues. The petitioner wins on either one. However, with the first issue, the narrow grounds addressing the right to travel, the petitioner does not need to prove a fundamental right to marry. On that first issue, in Shapiro v. Thompson, the court reiterated the fundamental right to travel. They cited United States v. Guest, saying that the constitutional right to travel from one state to another is a concept that occupies a position fundamental to the notion of our federal union.
But counsel, there are plenty of times when the right to travel is regulated. For example, if you're on probation and you go across state lines, you're breaking probation and you go back to prison. If you have a license and you go to buy liquor at a liquor store in another state and that state refuses to recognize that license is valid, you can't buy liquor in that state. How is this any different?
It is different, Your Honor, because Shapiro sets up a two-pronged test, which those instances would fail. The first prong is whether or not the state is distinguishing, or is making an invidious distinction between two classes of individuals. In those states, they were applying the categories to everybody. If you have done this, you may not.
Counsel, doesn't that depend on us expanding on the holding in Shapiro? Okay. Because citizens who already live in Olympus also can cease to be married, who are homosexuals. It has nothing to do with whether or not they had lived there or are traveling there. Anybody in Olympus cannot marry someone of his or her same sex.
Yes, Your Honor. However, it is the action of entering the state which has harmed Mr. Bronner and Mr. Comerford. Their marriage license is no longer recognized, and their marriage no longer exists. They're no longer a family. Shapiro versus Thompson called this a chilling effect upon their ability to travel.
Counsel, you said they're not a family, but they can have children by by traditional means outside of the state, aside from the state blessing their marriage. They can still have children.
Perhaps, Your Honor, adoption for same-sex couples is prohibited by Olympus, though. By natural means, perhaps, yes. Returning to the two-part test by Shapiro, the first distinction was whether or not the state had made an invidious distinction between two classes of individuals. And to look at this test, we can turn to Roma versus Evans. Roma versus Evans cited the Department of Agriculture versus Moreno, saying that when the state seeks to harm a politically unpopular group of people, it is never a legitimate interest. The purpose of legislation is to promote and protect a certain kind of behavior, not to harm a certain group.
Well, counsel, in Romer, didn't the Colorado bill disallow reconsideration about protection of homosexual rights? What I'm saying is the bill was two parts. One, there is no special protections for homosexuals. Two, this issue may never be readdressed. Isn't that on which the court found invidious discrimination towards homosexuals?
Yes, Your Honor, that was the main thrust of the case.
And there is no part of this bill that Olympus passed saying they could never reconsider that issue.
No, Your Honor. However, the state of Olympus has made a distinction between same-sex couples and homosexual couples without making it clear what they are protecting and promoting. Rather, they are merely harming same-sex couples. On the second prong of the test, the state must be able to prove that they have not deliberately fenced out a certain class of individuals. If we look at the record makes it clear that the state of Olympus passed Proposition 225 as a result of hearing of this SJC of Massachusetts decision in Goodrich versus the Department of Public Health. It was in a direct response to the ruling of the Supreme Court of Massachusetts. Furthermore, 3/4 of Proposition 225 is directed at those who live outside of the state. Clearly, the state is intending, and this is the effect of their legislation, to keep out same-sex couples. Thus, the state has filled both prongs of the Shapiro test.
But I don't think it's their intention to keep out same-sex couples. I think it's their intention to ensure that everyone in the state has health insurance. I mean, I don't see how the correlation between what, I'm not understanding what you're saying. Can you clarify?
Yes, Your Honor, I'll try. The state, when they enacted Proposition 225, they weren't particularly concerned about health care benefits, according to the record. They were responding to the Supreme Judicial Court of Massachusetts decision. It was, in effect, a statute that was passed simply to prevent same-sex marriages from occurring within the state. But if that was their only intent, simply to prevent same-sex marriages from occurring within the state, surely 3/4 of the proposition would not be directed at those outside of the state.
Well, as Justice Powell said in his concurring opinion in Zablocki, the state has an interest in preserving and considering the values of the people living within that state when making domestic rules. Now, why shouldn't the court today consider the fact that 45 states in this country do not want to legitimize homosexual marriages? Shouldn't this court at least somewhat consider public opinion? Isn't that crucial for us?
Yes, Your Honor, the court should consider it. However, in Zablocki versus Redhill, the court did overturn the state statute. If there's a 14th Amendment right to marry, which there is, according to Zablocki versus Redhill, the opinion of the public is irrelevant. The Constitution does override the vote of the people, which has happened to Mr. Comerford and Mr. Bronner.
I believe we iterated several times that the notion of marriage in a traditional sense is a fundamental right.
Yes.
Have we ever held that that traditional sense applies to members of the same sex?
The court has not specifically applied that to members of the same sex. However, Zablocki versus Redhill said the right to marry is of fundamental importance for all individuals. The court did not make a distinction based on gender. If we look at Lawrence versus Texas, the court overturned a state statute against sodomy and other forms of intimacy that happened within a person's home. Prior to Lawrence, the court had upheld all of those statutes banning those forms of intimate behavior. Thus, it made sense for the states to be able to prohibit same-sex marriages.
But counsel, wasn't that case based on a criminal statute?
Yes, Your Honor, it was. However, since it is no longer criminalized, that kind of activity, the states no longer have a legitimate basis for banning same-sex marriage.
I don't see the correlation between all cases of sodomy and all cases of homosexuality. Correct me if I'm wrong, but I believe sodomy can occur in a heterosexual marriage as well. So I think you asking us to conclude that simply because sodomy is now legal, all same-sex marriages should be legal as well is a bit of a reach. Don't you agree?
Feel free to answer. I see.
Thank you. No, Your Honor, because Lawrence versus Texas was addressing all forms of intimacy that happen within a person's home. There's a right to privacy there. And since those forms of intimacy are no longer illegal, and they are assumed within the context of marriage, as in Griswold, there's no basis for the state to say that marriage, the definition of marriage, cannot apply to Mr. Bronner and Mr. Comerford. Thank you.
Thank you, Counsel.
Mr. Chief Justice, and may it please the court, my name is Alan Carrillo, and I represent the United States of America. My esteemed co-counsel, Aaron Kamakavivole, represents the state of Olympus. The question before the court is whether Congress, in enacting the Affordable Health Care Act, exceeded its constitutional authority granted to it under the Commerce Clause. Now, looking at the facts of the case, the precedent set by this court, and the text of the Constitution itself, respondent believes it is clear that Congress did not exceed its constitutional authority, and therefore we respectfully ask this court to rule that the Affordable Health Care Act is a legitimate use of Congress's constitutional power. We ask this for three reasons. First is that there exists economic activity for Congress to regulate and protect. Second, respondents argue that petitioner, Mr. Bobby Bronner and Mr. Chester Comerford, do not have standing to challenge the individual requirement mandate in the Affordable Health Care Act. And finally, that the individual requirement mandate is necessary and proper for effective regulation.
Let's move right to your third point in your argument.
It's necessary and proper, Your Honor?
Yes, please.
Starting with necessary and proper, if we look to United States versus Comstock, it said that a law passed by Congress is necessary and proper if it is rationally related to a constitutionally enumerated power. So obviously this begs the question, well, two questions. First is if the Affordable Health Care Act stems from the constitutionally enumerated power to regulate commerce. And secondly, if the individual requirement is rationally connected to that. So first I'll turn to the interstate commerce portion of this necessary and proper argument. We would argue, the respondent argues, that indeed the healthcare market and health insurance market and the decisions involved are directly derived from the interstate commerce, and therefore Congress has the power to regulate it. And there are multiple reasons for this. If the justices will turn to Appendix 2, Section 2, subsection A of the record, it states that the individual requirement and all the other requirements in the Affordable Health Care Act mandate decisions that are economic and commercial in nature, particularly the economic and financial decisions of how and when health care is purchased and when health insurance is also bought.
But in Hodel, cited in Morrison, we did say that congressional findings standing alone were not sufficient to find rational basis for a particular act of Congress.
Correct, Your Honor. I'll first present the congressional findings and move on to some of the facts of the case that demonstrate this truth as well. In addition, in the congressional findings under Appendix 2, Section 2, subsection I of the record, it states that most Americans, if not all of them, will at some point need the care of a doctor, a hospital, or a health clinic. In addition to this, looking back under subsection B of the findings, it states that health care and health insurance are exactly interstate commerce, in the sense that health care takes place at an interstate commerce level, and the claims paid to health insurance companies take place at an interstate commerce level because insurance companies, by their nature, are national or regional. So looking at the congressional findings, we see it's clear that there is interstate commerce taking effect.
Certainly, and then the Congress can regulate it in that respect. However, how can you say that by indicating whether a person should choose or not choose a specific health plan or even purchase it in general, how is that even regulating commerce?
Yes, Your Honor. We would see respondent would argue that the healthcare market and the health insurance market are first two very unique markets, but secondly, just interlinked as a nature of themselves. And because of the fact that every American participates in the healthcare market just by default, and this is shown for three reasons. Americans can never fully opt out of the healthcare market. For example, if you're in a car accident, you are required to be taken to the hospital, and the hospital is required to give you treatment. And secondly, because you're automatically put into the health risk pool for the insurance market. I find it interesting that 40 million Americans haven't purchased health insurance, but that number is added to the health insurance risk pool because they're directly involved in the healthcare market and directly affect the health insurance market.
Well, counsel, your argument is well taken, but I believe we've said at several junctions, Wicker and its progeny, that this court is concerned about the ever obliterating distinction between purely local intrastate commerce that is beyond the powers of Congress. I fear that under your theory, we the court could endorse congressional intervention into other involuntary mechanisms of human life.
I have a few responses to that, Your Honor. First is in Wicker versus Filbert and Gonzalez versus Wright. The Congress only were regulating individuals that were already involved in a market. In the same way, with the Affordable Health Care Act, Congress is regulating individuals involved in the market, the healthcare market. It has set forth requirements on how best they can function in that market and how to make the market more effective for the rest of the country. Now, secondly on that fact, is there are already limits imposed by United States versus Lopez and United States versus Morrison that Congress can't just regulate that which substantially affects interstate commerce, but it has to be economic activity. And as the findings state, and as just common sense shows in regards to the healthcare market, the decisions regarding buying and purchasing healthcare and the fact that all Americans are involved in the healthcare market, in addition to buying health insurance, are economic in nature. Now, finally, looking at the necessary and proper clause, we can clearly see this is rationally connected to regulating interstate commerce. Now, for example, looking at Gonzalez versus Reich, this court determined that if there is a greater regulation scheme, that the court or the Congress can take steps to have that regulation scheme actually work. In fact, Justice Scalia, in his concurring opinion, went so far to say that non-commercial activity could be regulated if failure to do so undercut the actual regulation scheme. But in order to balance this, he said it has to be for a legitimate end with a reasonable means. Now, clearly, it's a legitimate end for Congress to regulate the national health insurance market because it falls in interstate commerce. Now, the question is it reasonable to mandate individuals buy health insurance for this regulation scheme? And the answer is yes. As the findings show, and as the facts show, with individuals not buying health insurance, these 40 million Americans, premiums are skyrocketing. Health insurance companies can't fully protect people with pre-existing conditions because all the healthy people are out of the health insurance pool. In addition, the market can't capitalize on the economic gains when people do not participate but still take from the healthcare market. In the same way, this is like the farmer Filburn, the worker versus Filburn, when he decided to gain from the wheat market without actually participating in it, not following the standards of the market as set by the Agricultural Adjustment Act of 1938.
The federal government didn't tell Filburn in the Agricultural Adjustment Act, oh, by the way, you have to grow this much wheat, and you have to grow wheat in general. They just said, if you supersede this amount, then you are in violation.
That's absolutely correct, Your Honor. In the same way, the government is not mandating people participate in healthcare because it can't. People just participate in healthcare by nature. This would be like Filburn participating in the wheat market. Now, the health insurance individual requirement mandate is just like the mandate in the Agricultural Adjustment Act of 1938 with the specific standards and how Filburn should conduct himself. The mandate to purchase insurance is just like a condition in participating in the healthcare market. And it is reasonable and it's connected to a legitimate end for interstate commerce, and therefore is necessary and proper.
Counsel, I'd like to turn to your second point. How does respondent contend petitioner has no standing?
Yes, Your Honor. If we turn to the facts of the case, we look at Mr. Bobby Bronner and Mr. Chester Comerford in Massachusetts. Now, Chester Comerford had health insurance provided by his job, and although Mr. Bobby Bronner did not have health insurance provided by his job and he didn't have individual insurance, well, one, Denolf Industries provided his health coverage in case of an emergency. But secondly, Comerford and Bronner were under a family plan in Massachusetts because their marriage is recognized there. Now, due to circumstances, Mr. Bobby Bronner and Mr. Chester Comerford moved to the state of Olympus. Now, in Olympus, Chester Comerford still had his individual plan for insurance because of his new job doing web design. Mr. Bobby Bronner still did not have insurance purchased by Denolf Industries, but it was still covered in case of an emergency. When the Affordable Health Care...
Isn't there a distinction between having health insurance and being... You argued earlier that emergency rooms must accept patrons' insurance or not.
Yes,
the fact that he's covered in an emergency is not the same as having health insurance.
Yes, Your Honor. And as I continue, what we see with the Affordable Health Care, when it was passed in January, or when it was taken into January 2010, in response to the Affordable Health Care Act, Mr. Bobby Bronner and Mr. Chester Comerford willingly decided to obey the law and the individual requirement mandate. In fact, they went to the insurance company to apply for a family insurance plan. They were denied because of Proposition 225. And now because of that, they decided not to purchase insurance and then filed suit against the Affordable Health Care Act and Proposition 225.
Okay, I'm still not understanding why they don't have standing to file suit.
Yes, Your Honor, because the facts of the case imply that they decided to willingly follow regardless of the fact that they were forced to buy insurance or not. The only reason they filed suit was not because they disagreed with the Affordable Health Care Act as applied, but because of Proposition 225, which restricted them from buying the insurance they actually wanted.
Counsel, one can agree to follow the law, but this court exists for one of the sole purposes is to strike down laws for which the United States Constitution does not grant power to.
Yes, Your Honor. If we look at Heller versus Doe, though, we also see the two cardinal rules by which this court must operate. The first is that only the facts provided by the petitioner in the case are really what we have to look to first. Now, obviously, the decisions are made for the whole country, but we have to first look to petitioner. Now, the facts state that they were willingly there to uphold the Affordable Health Care Act. The only reason they filed suit was not because they disagreed with the Health Care Act on its face, but because Proposition 225 restricted them from getting what they wanted.
Sorry, if I may, but standing it's not based on whether they exercise their right or not. You either have standing or you don't because you have a claim. And they do have a claim in this instance. They are wronged by the law.
You may answer.
Thank you. The wrong where they're filing claim is not necessarily the fact that the individual requirement mandate requires them by insurance, but rather Proposition 225. This is the sole motivation for their claims because they cannot purchase the insurance they originally wanted.
But regardless of the motivation, they still have a claim, and that thus creates standing.
In that case, Your Honor, they could move to another state such as Massachusetts where they would still buy a family plan and not file suit against the Affordable Health Care Act. And because that, I ask you to look for the respondent.
Mr. Chief Justice, Associate Justices, and may it please the Court, my name is Aaron Kamaka Vivo Ole, and I rise to defend the state of Olympus. We ask this Court to rule that the Massachusetts marriage license issued to petitioners does not need to be recognized within the jurisdiction of the state of Olympus. And we ask this for 3 reasons. The first is more of a preliminary question regarding what standard of review we should use today, whether we should grant it the fundamental rights protection that we did in Loving v. Virginia, or whether we should protect it as a right of non-fundamental nature as we did in Lawrence v. Texas. Using the rational basis review that this Court gave in Lawrence, we will then also discover that, yes, rational basis review is merited, and that second, there is no form of invidious discrimination against a suspect class. Finally, I would like to address opposing counsel's arguments regarding the full faith and credit clause, and specifically how the right to travel doctrine articulated in Shapiro does not apply in the case of Barr.
Why don't we start with why the right to travel does not apply in this present case, counsel?
Yes, Your Honor. To understand this, I would like to very briefly discuss what fundamental right status guarantees and what specifically garners that form of protection. In Shapiro v. Thompson, they articulated that there is a fundamental right to travel from one state to another state while receiving the same legal protections that should be guaranteed under the 14th Amendment. Interestingly enough, however, we don't have that in the case of Barr, because fundamental to the idea of travel doctrine is that an individual is in fact traveling. Rather, what we have in the case of Barr is a group of individuals who from mid-2008 to January of 2010 at minimum had absolutely no traveling intercourse in that sense between Massachusetts and the state of Olympus. Instead, they were domiciled within the state of Olympus, conducting all of their affairs within the state. We would therefore contend that the proper controlling doctrine should be found in Williams v. North Carolina.
Well, counsel, just out of curiosity, though, with respect to the right to travel, as I understand it, you're arguing that the law was passed some considerable time after they moved there. What if the law was passed the next day?
Your Honor, 2 responses to that. First, as a matter of course, I don't know exactly how that would work, primarily because of some ambiguity within the record as to what precisely is being denied petitioners as the right to marry. And we'll get into that a little later when we talk about invidious discrimination. But the other thing is a simple matter of the fact that they were intending to live within the state of Olympus. And we see this by their actual own actions. Before moving to the state of Olympus in mid-2008, they traveled across state boundaries from Massachusetts to the state of Olympus, commuting for hours 5 days a week in order to avoid being seen as citizens of the state of Olympus. Interestingly enough, however, in mid-2008, they voluntarily chose to come over to the state of Olympus, thereby indicating that they were subjecting themselves to the law.
Well, by voluntarily, you mean because one of them lost their jobs and they had to move.
Actually, Your Honor, according to the record, the job was actually lost sometime before and they still decided to commute. It was only afterwards, after some substantial time, and I will definitely grant it some financial burden, that they did in fact choose to cross over to the state of Olympus. Interestingly enough, however, financial burden has never been used as a reason for an individual being coerced into a policy which, by the way, was never even being applied to petitioners until they challenged in federal court against the Affordable Health Care Act.
Well, counsel, to your first point in your opening statement, financial burdens we also explicitly prohibited that use when concerning rational basis reviewing a state's law.
Absolutely, Your Honor, and we would not contend that financial considerations at all should be granted for rational basis review on either side. We would instead contend that there is a much deeper tradition that should be protected, that has been fundamentally protected by this court before, and should continue to stand within the realm of state jurisdiction.
Well, didn't we stand for the tradition that marriage was between members of the same race until 1967?
Absolutely, Your Honor. However, of course, the instance in Loving v. Virginia is a very interesting one which I would like to spend some time on, especially since opposing counsels used it heavily. In Loving v. Virginia, we have a group of individuals who, because the 14th Amendment protected their rights as individuals from discrimination based on race, we had a challenge made in Loving v. Virginia. Furthermore, under the Civil Rights Act, which was also implicated in Loving v. Virginia, the individuals were obviously being denied a right that was fundamental in nature. But the fundamental nature of it was not due to the fact of what race an individual was. Rather, as cited in Loving v. Virginia, we have Atherton v. Atherton, which states that a husband without a wife and a wife without a husband is unknown to the law. The understanding of a fundamental right status had nothing to do with race. It had everything to do with the individuals in question, that an individual had the right to choose his or her partner, put in parentheses there, of a different gender, regardless of race. Our understanding is further confirmed when we look into Blocky v. Redhill, where this court stated that, yes, there is a fundamental right to marriage, as my beautiful co-counsel argued, beautiful opposing counsel argued, but as we also look at it, we find that they go deeper than this. They continue to implicate that in accordance with Griswold v. Connecticut, the child-bearing statute that was first articulated in Williams v. North Carolina was indeed struck. Then they added the child-bearing statute. And following this, at 491 of their decision, the court stated, quote, "Surely the right to marry and raise a child in a traditional family setting," end quote,
Counsel,
garners
that,
equal protection.
let me cut you off, I'm sorry. That assumes that we hold that homosexuals raising a child is not traditional. Couldn't one draw the distinction between traditional family settings at, say, adoption, where in our situation, someone who has a homosexual has a child by natural means is still traditionally raising a family?
Yes, Your Honor. To this, I'd like to turn not to this court's opinion, because this court has not issued an opinion as to what precisely that traditional family setting would look like, but rather look to a very helpful decision issued by the Massachusetts Supreme Judicial Court in Goodrich v. Department of Public Health. There, the court considered what precisely was being protected when they legalized same-sex marriage. And they determined that they were not protecting some sort of traditional family setting. Rather, they openly admit at the very beginning, at the very outset, that they were breaking new ground. We understand here that, yes, there is some form of protection under a non-fundamental emerging rights status, as this court recognized in Lawrence v. Texas, but it is not the fundamental right to marriage that we have traditionally recognized. Because of this, as we look at rational basis review, we find that the state, as long as it can show a reasonable set of facts that can demonstrate that they are in fact acting in a rational manner, as cited in this record in Heller v. Doe, that we do have a reasonable basis for processing Proposition 225. We look first to opposing counsel's argument regarding its extraterritorial nature, since according to Zablocki v. Redhill, an extraterritorial statute is on its face unconstitutional. However, as we look at the text of Proposition 225, it by no means attempts to legalize and tell other states how they should interpret marriage. In fact, in the Goodrich decision, they discussed this at length, noting that even the Goodrich v. Department of Public Health court determined that they were by no means intending to advance their definition upon another state.
Counsel, can't we look at the actual language of the proposition to see what the legislature was trying to say? I'm going to quote here, "Whether within or outside the state of Olympus, the United States, same-sex marriage between persons of the same sex is void within the state of Olympus." And what I'm saying is, you're right, that they're not physically telling other states that you can't allow marriage, but can't we infer that from the text of the proposition?
No, Your Honor, we believe that we cannot do that. And the major reason for this is by the definition of Olympus as it has been used in the past. We should not merely look to the actual text of the document, we should look at how it has been used, since that will help to define the difficult portions for us.
Well, Counsel, I read this was passed 2006. Do we have any text to look at into what Olympus traditionally defined as marriage before?
Yes, Your Honor, to some extent we do, or at least not to what they defined it as before, with the sole exception that we know that they have a long-standing tradition within the state of recognizing traditional marriage. We do have that. But looking even at the timeline itself, we discover what the meaning is behind Proposition 225. We find, as Your Honor mentioned, that it was passed and first took effect on January 1st, 2006. But if Your Honors would kindly turn to page 5 of the record, Justice Foster of the lower court determined that, quote, Olympus law prior to 2008 did not refuse to recognize same-sex marriage licenses. We may therefore consider that it is definitely not extraterritorial in nature. It is most certainly not self-executing, as we had in Zablocki v. Redhill and Romer v. Evans, respectively, on account of it didn't have any effect for the first 2 years of its existence. We can definitely see that this was by no means intended to impact the other states of the Union, since it had absolutely no impact. Instead, within the state of Olympus, it was merely designed to demonstrate their policy. And we would contend that the public policy exception that this court has routinely respected does grant us a rational basis under this court's jurisdiction.
Well, Counsel, if we find that, as Petitioner's Counsel argued, that the 14th Amendment is at issue and in violation, as I understand the text, that no state shall deprive rights and so on and so forth, the public policy exception would not apply. We're saying that all states must obey these commands. Public
Yes.
policy exception is limited.
Yes, Your Honor, definitely there are limits to it. We would not intend to compromise that. However, with my short remaining time, I'd like to very briefly answer the question. The truth of the matter is we have to turn back to the 14th Amendment itself, because there was a very critical portion of the Section 1 of the 14th Amendment that was not recited here, and that is that these only apply to the rights of citizens of the United States. It has not been shown by opposing counsel that this is in fact a fundamental right that should not be deprived by the states of citizens of the United States. In fact, the record in Sosna versus, if I may briefly conclude,
Please go
Your
ahead.
Honors. In Sosna versus Iowa, as cited in Zablocki, it appears that the right to determine how marriages may be created and how they may be dissolved is the, quote, absolute right, end quote, of the state.
Counsel, one last question. That may be so, but again, I refer back to the beginning text of the 14th Amendment that prohibits states from denying protection of its own laws.
Yes, Your Honor, I see that my time is running out. May I briefly
Field goal, free go.
Thank you, Your Honor. We would contend that definitely there is a protection of the 14th Amendment against state action, but the 14th Amendment was by no means meaning to enslave states in order to free individuals. The proper understanding of the 14th Amendment in conjunction with the Article 4 of Section 2 of the Constitution was designed to grant both the states the ability to have their own jurisdiction and complete control within certain bounds within that jurisdiction.
Thank you, Counsel.
May it please the court. Under the Commerce Clause, Congress has exceeded its authority to regulate and protect. The explicit wording of the Commerce Clause gives Congress authority to regulate interstate commerce, and from this the court has inferred the ability to protect, as in Perez versus the United States, where this court gave Congress the ability to regulate and protect channels and instrumentalities of interstate commerce and to regulate that which has a substantial effect. However, it is not within our record when the court has ever allowed Congress to mandate participation. Even the broadest cases within our record, namely Wickard versus Filburn and Gonzalez versus Rake, has this court allowed Congress to mandate participation. In both of those cases, individuals were already growing wheat. They were already growing marijuana. They were already participating in an activity.
Well, what would you say, Counselor, if I said that, as is stated in the facts, Petitioner Bronner, I believe, already had health insurance prior to moving to Olympus?
Well, Your Honor, since the fact that he has insurance already doesn't mean that the AHCA does not exceed Congress's authority. He's still required to have it, and that does exceed Congress's authority. They may regulate the health insurance industry once he has it, certainly, and they may tell him what he may and may not do with it, certainly, but they may not require him to buy it. Turning to the 14th Amendment, Shapiro versus Thompson does apply today in spite of the fact that Bronner and Comerford were already domiciled within the state. Looking to the facts of Shapiro versus Thompson, the young lady who moved to the state with her baby, she lived there when she sued the state for welfare benefits. This is the same today. Mr. Bronner and Mr. Comerford do live there. However, they lost their marriage license and their status as a family upon moving.
Well, Counsel, I think Respondent was trying to articulate that it's not an issue of whether or not the person was so discouraged from moving into a state that he or she decided to forego doing so, but rather whether that discouragement occurred at the time the person was deciding to move. In Shapiro, if I recall the facts correctly, that the issue of refusing welfare benefits to those who lived within the state for a year was already existing at the time Ms. Shapiro was to move. In the current case, however, that statute was not passed yet.
I see, Your Honor. However, the Shapiro test did indicate that if a state is attempting to fence out a certain class of individuals, that the statute does not stand. It does seem clear that the state of Olympus would rather Mr. Bronner and Mr. Comerford move back to Massachusetts, and it's encouraging them to do so, so that they can be recognized as a family. Thus, we ask you to side with the petitioner.
Thank you, Counsel. Okay, please. As the number of teams get smaller, the competition gets better, and that is only patently shown in the outstanding advocacy I've seen today. It was not an easy decision. It was a split decision. It was not unanimous. We, however, find the winners, the respondents. That being said, both sides advocated admirably. I will forego individual comments because I know no one, myself included, wants to hear them. All I can say is great use of cases, even the use of secondary cases. Some people think that that's too finite, but if it accentuates your point, it's a great thing to do. Those of you who used it did it admirably. And finally, I like it when advocates set up the standard of review the court's supposed to use, and they articulate exactly what that is. It's important because sometimes we think of these terms as, just metaphysical, rational basis, judicial strict scrutiny, but setting up what it is important so it gets us to the actual issue as to whether or not it meets that burden. And that is all from me. I will turn it over to the associates.
I was very impressed by everyone here. Your ability to smoothly wrap in arguments that were raised by your opponents, I just thought that was phenomenal. You all stood firm in your convictions. That's very impressive to me. And I thought you used nice transitional sentences and phrases, and you had very sophisticated arguments. Your delivery was clear and concise. It was really a tough decision, and I think everybody is due congratulations. You'll be fine in life. Seriously.
Agreed. I think you guys did a phenomenal job across the board. I said it in the last room, and I'll say it again. I think you argue better than most counsel I see in court on a daily basis, including myself. I will say that. The only comment I would have and make is that you shouldn't ever comment on opposing counsel's physical features in a courtroom. And you knew that was coming. It has no place in the law, and actually, I don't think I listened to one word you said after that, because it just brings a distaste to the room. I would just not do that in the future. But otherwise, I applaud all of you. Congratulations and good luck.
I don't have anything to add, really. You guys were all great. The one thing that I did write down throughout it that I just really liked, and I'm not even sure who said it at this point, but someone, I think it was on your side, referred to a car accident, and how in a car accident you have no choice to opt out of going to the ER. And I really liked that, because I've been hearing the argument all day that you unwillingly participate, and that made sense to me, but that really clarified the point for me. So I thought that was great.
Just one last thing. I agree with my associate's comment about commenting on physical appearance. This panel in no way discounts counsel's remark. You are all beautiful people inside and out.
So our runners-up, regional finalists Andrew Ferguson and Shannon Healy, Patrick Henry College.
Congratulations.
We're having a lot of firsts. Last year we had our first three-time champion in history. This is our first relative former champion in history. Aaron's brother Peter is a former champion of this region as well. Our champions this year, Aaron Kamakavigo and Alan Carrillo. And finally, come up and accept the championship award for the school. For the 8th time in 10 years?
Yeah.
Collecting the award?
Give someone else a chance.
Yes.